Hey real estate professionals, welcome to Velocity Title's Title Minute. Today you'll be hearing from our expert real estate attorney, Russell Donaldson. He'll be sharing the legal scoop on transferring assets. Protect your family's estate. Afterwards, feel free to send in any questions or comments you might have, and we'll get back to you as soon as we can. And now, here's Glenn.
Thank you again, Lauren, and everybody. Welcome back to the Title Minute by Velocity National Title Company. Once again, I'm Glenn Russell Donaldson, your real estate attorney, and today we're going to be talking about one of the things in law that is very closely related to real estate law, and that is the way you title family assets. One of the big and most important parts of advising a client in the practice of real property law is understanding how to protect that asset for my clients. And as real estate professionals, you need to put this in your quiver as one of the arrows that you have to be able to advise your client properly on how to protect that likely largest single asset most people will ever acquire in their lifetime, and that is their family home. Many times over the course of my career, I've had people come in and say, I'm getting older, I want to protect my home, I want to protect my assets, I want to make sure that the value of my hard work gets passed on to my kids. And they're looking to change the way they have titled their home, their family home, so that they can add their children to the title. And one of the biggest mistakes people make is they simply say, I want to add my kids to my title. Well, folks, that's a real big problem in many cases by simply adding your kids to your title. And that's because when you do that, whatever baggage that your children have or your client's children have, that attaches to that real estate. If that kid goes out and gets in a car accident that's a catastrophic accident and there is a extremely large judgment that would attach against that child, well, that judgment can also attach against their interest in the real estate. Without getting overly complicated, but most of you real estate professionals understand the various ways to take title in real property. One is as a sole owner, one is as a tenant in common, one is as a joint tenant, and of course, one is for husband and wife as a tenant by the entirety. And those distinct forms of ownership have some real value to each and every one of them. Obviously, a sole owner title is for an individual or an entity to own that property 100% without partnership or some other arrangement. A tenant in common is an interest in real estate between two or more persons where the individual's interests passes to their heirs upon their death, not to the other partners in the real estate transaction. And of course, joint tenants also shares a right of survivorship in the actual partners. So if one of the partners passes away prematurely, their interest passes to the remaining tenants in that ownership of real property. Tenants by the entirety is something that's reserved for husband and wife, and the benefits of that are that, number one, you have rights of survivorship. If either spouse passes away, then the interest becomes sole in the surviving spouse. Then number two, there's something called judgment protection. So if one of the spouses is slammed with a judgment out of some matter relating to business or a negligent tort or otherwise, well, that judgment does not attach to real property. That's very important when you start looking at how you're going to pass that asset to your kids. If you own that real property as a tenant by the entirety and you want to preserve that tenant by the entirety interest, you can do so. And one of the most important ways to do this is what's called a life estate deed. Now, we don't have enough time to talk about all the variable options but I do want to focus today on the life estate deed and protecting your family's estate. The life estate deed allows some parents who own their property to pass the property to the children immediately upon their death without the necessity of opening an estate or creating a trust or anything else. What they simply do is execute a new deed to themselves as life tenants and then to their children immediately upon the death of the last spouse, the last parent. That happens automatically by operation of law, and it does not require an attorney to go down and file an estate, and it does not require a trust or other will in order to accomplish. It's a simple mechanism that you can use and you can advise your clients to use to protect that family asset. Remember, if you have contract questions, reach out to us at contractquestions@velocitytitle.com or 1-800-MY-RE-LAW. That's 1-800-MY-RE-LAW, which is 1-800-697-3529. Once again, your real estate attorney, Glenn Donaldson. Have a great day.